relations, cooperation relations between many countries, not only under the base of treaties, but also in keeping the integrity of judicial systems. So as many of you may know, one of the most interesting things about extradition is the figure of extradition per se, because although it's a long data figure in terms of historical moments, the figure of extradition has always kept, in terms of the countries, a lot of importance in terms of what are the capabilities of one state to actually prosecute their own criminal offenders, and whether or not the major capabilities or the best capabilities are related into third-party countries that may have some relation with the specific criminal conduct. So extradition is designated as the official surrender of an alleged offender from justice, regardless his or her consent, by the authorities of the state of residence to the authorities of another state for the pursuance of the criminal prosecution or the execution of sentence. And this is one of the most important aspects of extradition, because normally people think of extradition as just for criminal prosecution, in terms of I'm going to surrender one specific person to a third state just for the initiation or the beginning of criminal procedure. But extradition also serves as a major figure in order to execute a sentence. That is, whether a judicial sentence has been already dictated by the criminal system of one state, and the only thing left is to actually execute the sentence, whether to process not only the part of prosecution, but actually the part of administrating justice or even imposing the sanctions. So extradition is, as I told you before, kind of the major reference in terms of mutual legal assistance in criminal matters. That is, one state initiate process of collaboration with a third state in order to consider or even in order to preserve the integrity of its own judicial system. So every single extradition is regarded as an agreement under international law. And that is because extradition is not an execution per se, or an execution even pre-facto or post-facto per se, but rather you as a state, you are required to have an agreement with the third state in order to initiate the process of extradition. The processes of extradition are of significant formalism. They require a lot of forms and a lot of specific documents in order to be carried out. And that's one of the major difference between other figures of criminal assistance, which also involves the figures of expulsion or even deportation. So you have to bear in mind that in mutual assistance in criminal matters, there are major, or most significantly, three major figures, which are extradition, expulsion, and deportation. The figure of extradition is the one that I previously mentioned, but there are also two other figures, expulsion and deportation. The figure of expulsion, it's considered per se as a motive for the return of an alleged offender from justice in non-maintaining the domestic public order, or even non-fulfilling with some specific aspects of law or enforcement of domestic law in one specific countries. In the vast majority of cases, people tend to confuse, although they are in some judicial case law considered as equals, the figures of expulsion and deportation. One of the major differences between expulsion and deportation is that deportation is related specifically to immigration affairs or immigration matters. When you have expulsion, you can be expelled by one country just for not fulfilling certain requirements of being in that specific country, or even because you are not entrusted by the local authorities to be someone that will preserve the peace and security of that specific third state. However, the figure of deportation only focuses on as to whether, in your case, you fulfill with the migration requirements to be legally in the territory of one country. And that's one of the major differences, or the most significant difference between this type of figures. So remember that extradition is when I surrender a specific criminal offender to the justice of another third state pursuant an agreement. The figure of expulsion is whether I do not fulfill with the domestic law or I am not entrusted as to be loyal or inconsistent with the public peace and morality of that specific country. The figure of deportation focuses more directly into migration affairs. So as you may understand about the figure of extradition, one of the fundamental, if not the fundamental element of the figure of extradition is precisely the element of consent. And that is because extradition is a figure governed by the Vienna Convention of the Law of the Treaties, because every extradition, it is considered per se as a treaty in its own nature. Every agreement and every process of consultation that lends or leads to a process of extradition, it's considered by nature and a specific treaty that it is encompassed or absorbed by a major treaty of mutual assistance criminal matters between one countries in relation to the field of extradition. So one of the major things that you, or one of the most important things that you have to bear in mind in terms of the figure of extradition is that when a state is authorized to exercise jurisdiction in terms of receiving an alleged criminal offender that is surrendered by a third state, is precisely whether there is an agreement to engage in the process of surrender of the alleged criminal offender. That's why it is considered that the state that is receiving the criminal offender is actually exercising jurisdiction in terms of criminal jurisdiction, of course. But extradition is not an open figure. Extradition has some limits, and those limits were analyzed in different case laws, even by the own decisions or the state opinions of the Supreme Court of Africa, or the case, or in the former tribunal in the criminal tribunal, sorry, for the former Yugoslavia in the case of Dragan Nikolic. It was considered that the figure of extradition retains some limits in terms to the respect of human rights, and whether in the process of surrender the criminal offender, there was evidence that such process was in violation and of significant violation of the human rights of the alleged criminal offender. And furthermore, as to whether the state that is initiating the process of surrendering the alleged criminal offender protests because it seems or it considers that there are some inconsistencies in terms of the process of extradition. So you have two major limits in terms of the figure of extradition, which are violations of human rights and as well manifested and expressed protest by the state surrendering, in which the state manifests that it does not express its consent or agreement as to initiate or continue the process of extradition. So most of there are some, and something that I believe will enlighten you in terms of your investigation, not only for the case, but whether if you are deviated from this specific branch of law, or you are likely able to pursue this type of field, or you like this type of field in which criminal law is related or connected with international law. This will essentially the legal evolution of the figure of extradition. So as you may see on screen, there are some iconic pictures of the context of battlefield. And you may think why these pictures are related to the figure of extradition. The figure of extradition is dated from long time ago, even from pre-Christian times or pre-Bible times, as to agreements between specific nations or populations in terms of the deserters or the peoples that left their armies in the context of battlefield or non-international or even armed conflicts, international armed conflicts between nations. The figure of deserters became of significant importance as to consolidate the figure of extradition. And that is because when one person or a palatine deserts to one specific country, the country of dissertation requests the devolution or even the return of that specific person or that specific palatine. And there are historical cases in which the receiving state actually engaged in the process of devolution. And that's the major precedent of the figure of extradition, which are the figure of deserters in the context of battlefield. But moving beyond the issue or the question of the historical development of the figure of extradition, something that you have to bear in mind is what is the current legal situation or the current legal status of the figure of extradition in international law, but also in domestic jurisdictions. You may have heard from time to time a lot of extraditions, especially from Latin American countries to the United States, of a specific criminal offenders, not only in the context of battlefield, but more precisely in the context of engaging in certain illicit acts or transnational criminal acts, including drug trafficking, arms smuggling, and even crimes that are considered as serious offenses to human rights law, not the traffic of persons, traffic of weapons, etc. So the legal framework as of today of the figure of extradition may be divided in like four preconditioned elements, which are the sources of the figure of extradition, the duty to extradite as a principle, also, and most importantly, the substantive law applicable to the figure of extradition, and the thing that you may relate in interest the most, which is the procedure of extradition and the related procedures that surrounded the figure of extradition. So in terms of sources, you have to bear in mind that the sources of contemporary extradition law are bilateral agreements and multilateral conventions on the one hand, and even so, the National Extradition Acts on the other. So you have figures under the framework of international law and figures under the framework of national law. In the case of Colombia, for example, which I can relate the most, we have a specific extradition act that is attached to the criminal procedure, the law of criminal procedure, and the criminal code, in which we define in which cases certain offenses may be subject to the extradition process and pursuant to which countries. While bilateral or multilateral agreements are the most often use of means in terms to establishing a process or even beginning a process of extradition, another approach is the uniform legislation around the world that seems to provide some sort of agreed schemes among the nations as to whether which type and which rules govern the figure of extradition, especially in terms of the European Union. You have uniform laws in terms of how to proceed in cases of extradition. In many countries, you have an agreement between the laws of Finland, Denmark, Iceland, Norway, the government of Sweden, in terms of a basic cooperation agreement of 1962, which is called the Helsinki Treaty. The Helsinki Treaty was like a guidance of how to govern the figure of extradition among specific countries, which are the countries that I previously mentioned. The member states of the Helsinki Treaty agreed in June of 2005 to modernize the treaty per se in order to make a cooperation a more relatable field of orientation of the extradition process and to make the extradition per se more effective. You have in the Commonwealth system, the Commonwealth scheme of rendition of persons or fugitive offenders, which was amended, if I am recalling correctly, in 1990. Of the European Union. This scheme is of the European Union, of course, and the European Arrest Warrant Act, in which you may see the rules of surrendering procedures between member states. And under the framework, of the European Arrest Warrant scheme and the European Arrest Warrant Act, you have the framework of decision of the European Arrest Warrant, which are those decisions specialized in terms of extradition among the countries of the European Union. Whether the provisions of an extradition treaty are taking precedence over those laid down by the National Extradition Act of many states, in terms of international law, you have also significant precedents in terms of the figure of extradition. Undoubtedly, one of the most significant case law was provided by the International Court of Justice per se in the case concerning obligation to prosecute or extradite between the governments of Belgium and the government of Senegal, in which it was analyzed precisely how the figure of extradition was governed by certain principles of international law. So that's a decision that you may want to look upon if whether you are analyzing the figure of extradition. Of course, one of the other decisions that may serve as a significant precedent in terms of, or not even precedents, but rather enlightening instruments in terms of auxiliary means of interpretation is the arrest warrant case of the International Court of Justice as well. Despite the fact that the most basic principles and rules provided in extradition treaties and schemes are based on national extradition statutes, they are almost identical to the figures of international law. The United Nations model rules of extraditions, specifically the model rule or the model law of extradition of 2004, in somehow takes elements of national statutes of extradition in order to consolidate the best practices of extradition among the nations that are party to the United Nations Charter. So then we should move on to the duty to extradite, which is possibly one of the most interesting elements in relation to the legal framework of this figure in per se. In general international law, per se, the general international law and general international law does not impose a specific duty of the states to extradite common criminal knots, nor it oblige, those states to prosecute or punish alleged offenders. What international law is in somehow serving as an instrument or even as a basis of relations among states is that there are some common grounds and efforts among nations in order to reject a specific criminal offenses. And whether if those criminal offenses are not prosecuted directly in your country or the country in which there are jurisdiction to prosecute those specific actions, then the duty to extradite comes to the table. And that is, there are some specific type of offenses in international law, including war crimes, including serious and grave violations to human rights, and specific crimes that are rejected by the international community, such as the crime of genocide or the crime of torture, in which you are required to prosecute under the framework of your own legal country or to extradite, whether you are unwilling or unable to initiate the process of prosecution. One of the major or the most prevalent instruments of long data was precisely the United Nations Charter and the Friendly Relations Declaration of 1917. The duty to extradite or prosecute an alleged offender does not exist or set on the basis of treaty fixing the prerequisites, but rather is an exceptional framework. It's not like a first hand or a first action imposed, because as you may somehow conclude, this duty to extradite in international law is of a complementary character because it is based or ruled under the principle of unwillingness or unableness, or whether you are unwilling or unable to prosecute those crimes within the framework of your country. And the best case to understand this situation is precisely the case concerning the obligation of prosecute or extradite of the International Court of Justice. Likewise, general international law contains no limitations on a state's freedom to extradite, except for those fundamental human rights that can be considered as part of jus cogens norms. This is a tricky issue because identifying or defining jus cogens norms is of significant difficulty, but there are some grounds as to whether to say this is of jus cogens. Therefore, states are on the obligation to respect that specific peremptory norm, or if not, possibly to extradite the person that violates or the group of persons that violates the peremptory norms in order for them to come to justice and not lead to a scenario of impunity. But the duty to extradite is in somehow handed to another principle, which we are going to see in the development of substantive law, which is the reciprocity principle. Is whether there are reciprocity scenarios or reciprocal scenarios between the countries that extradite or prosecute. And then we will finally, then in the final parts of this lecture, we are going to assess the procedure and some general aspects of the procedure of extradition. But in terms of principles, you have to make a difference between the principles per se that govern the rules of extradition and the circumstances that preclude the return of a criminal offender. So we are going to move first to the principles, and every single extradition subject is subject, sorry for the redundancy, to the rules applicable to the treaty or the statute in which the extradition is portrayed. But normally, in the absence of a treaty, there are some principles that may seem of universal convention or even part of customary international law that may govern certain rules of procedures or certain considerations that states initiating the process of extradition may have to consider when initiating this process. The first of these principles is the extraditable offenses. All the treaties and statutes specify by the name the offenses for which extradition is available. But in nowadays case law, and even nowadays cases which are not necessarily governed by judicial precedent or even a judicial decision, there is no specific clarity in the vast majority of treaties as to whether which type of offenses are subject to extradition, but rather it depends vastly on process of consultations among the countries. The country that is requiring the criminal offender and the country that is surrendering the criminal offender. So they can, in general, the treaties may have the opportunity to describe, or at least may have the opportunity to put on a list of the criminal offenses that may be subject to extradition. But nowadays, that is governed by political and diplomatic relations as well. So the fact that a treaty does govern a list or portray a list of possible criminal or extraditable offenses, that does not necessarily imply that any other offenses may not be subject to extradition if by up-to-date meanings of negotiation or direct consultation among countries, that figure is considered to be subject, or it is considered to be an extraditable offense. The other principle that you have to consider is the double criminality rule. The double criminality rule requires that an act shall not be extraditable unless it constitutes a crime under the laws of the both countries. You cannot pursue a crime that it is not legislated as an offense in your jurisdiction, nor even you may surrender that specific act to a state that has that jurisdiction or even has that law that says that it is a criminal offense if in your country it is not considered to be a criminal offense. So there has to be a reciprocity in law as well. Rarely implemented, the rule does not require, and this has to be one of your first consideration, is that the legislation of both countries shall not be identical, but rather shall consider in its integrity that certain type of conducts may be subject to criminal prosecution. Recent extradition treaties, for example, the UN Convention Against Transnational Organized Crime, of the 2000, and the International Convention of the Suppression of Financing Terrorism, provide more and more exceptions from double criminality rule by accepting the demand of the requesting state exercising jurisdiction, which means that you don't require specifically that, and nowadays some treaties, and this is one of the exceptions to the double criminality rule, that nowadays one treaty or even the laws of two different jurisdictions in terms of countries do not necessarily require to have the same type of criminal law or criminal conduct or to describe a specific offense for it to be subject to extradition, but it will depend as to whether the treaty allows for this figure. That's the clear example of the Convention Against the Financiation of Terrorism, in which it is considered that as general financing terrorism, it's an offense that should be subject of extradition if it's not prosecuted in one country that alleges that the specific conduct is not subject to the legislative part or the peremptory principle of national legislation, which implies that it is considered an offense in its own country. This convention provides a specific figure that says that I don't care whether your law says that it is not a specific criminal offense. If you are party of the treaty, specifically, for example, for example, in case of the Convention Against the Financiation of Terrorism, it is considered it is considered that if you are party to the treaty and you don't have a legislation that forbids the issue of financing terrorism as a criminal offense, that is not an excuse to be subject to extradition pursuant the treaty itself. Another of the principles that must be considered is the evidence of guilt. Courts in common law countries require, broadly speaking, that a requesting state makes out a prima facie case of guilt against an alleged offender, justifying his or her committal for trial under its own legal system before it will grant the extradition. What is the meaning of this principle? That prior to initiate the process of extradition, it should be at least beyond any reasonable doubt that there is evidence of guilt, that you are likely to be declared guilty in your country, and therefore you may be subject to extradition. Because in terms of common sense, if you're not guilty in your own state, then why you should be subject to the rules of another state that is requiring you for a criminal offense? So that's the issue of evidence of guilt, that at least beyond any reasonable doubt, it can be proved that you commit or did you have the intention, or did you have the intention to commit that specific act as considered to be a criminal offense. For example, in civil law countries, as in the case of Colombia and the vast majority of Latin American countries, do request, however, additional evidence, including not only the evidence of guilt, but from the circumstances of the case, the reasonable doubt as surpassed, whether the requested person in fact committed the offense by itself, or whether it was a joint criminal enterprise, or even a situation of co-authorship, or even determination of authors in terms of the theories of responsibility and guilt in international and also national criminal laws. And then it comes one of the most fundamental principles in terms of extradition, which is the principle of reciprocity. The principle of reciprocity traditionally is underlined as the whole structure of extradition, where general extradition relations are established by virtue of a treaty. Reciprocity, to a large extent, is guaranteed. That is that although even here optional grounds for denying extradition must be put on the table, if there is not a question of reciprocity among countries, or whether we have the same considerations as to whether the figure shall be subject to extradition or not, then reciprocity will affect the whole relation of the extradition process. And that is whether, in more likely words, whether if I extradite, then I shall be allowed to request extradition to my country, and you will be likely to concede that extradition to me because I concede extraditions towards request of your state. So that there has to be a reciprocity. The precondition of a strict reciprocity is, however, implicitly considered as being detrimental of the interest of justice, because just consider for a moment that if you didn't we have a specific criminal offense, for example, a war crime, that in my case as Colombia, I'm not allowed, or I am unwilling to prosecute, investigate, sanction, then I shall extradite to a treaty that has to a specific third party for which I have a treaty of extradition. And then this is a serious criminal offense, then I shall extradite it. But because it's the position of my state to just Since your state is now requesting the surrender of a criminal offender, but in normal cases, when I request the surrender of criminal offenders from your state, you don't give me the approval to initiate the process of extradition, that I'm not going to extradite this criminal offender that commit war crimes. This is really debated and really discussed among the international community, even in the framework of the United Nations, because in somehow that will jeopardize the function of justice and the function of extradition per se. But in terms of strict reciprocity, which is alleged by many states in terms of applying the figure of extradition, that's the interpretation that they give to the principle, is that if I am able to extradite, and you still be able to extradite towards my country. And if not, then we have a broken relationship. And finally, in terms of the principles, we have the speciality rule. Under the speciality rule, incorporated in almost every treaty and statute, and it is considered by vast majority of countries as a rule of general international law, and some countries as a rule of customary international character. An alleged offender may not be detained, tried, or in any way punished in the requesting state for any offense committed prior to surrender other than one from the extradition was granted. In normal sense, if I am extradited for more specific offense, I am not in terms of in process of extradition, I should not be subject to additional investigations for actions committed prior to the authorization of extradition. That's something similar to the legality principle, is that if I am extradited for one specific conduct, the process of extradition and investigation in the third country, which is the receiving state, should be entirely based only in the context of the offenses that were authorized pursuant the extradition agreement. Maybe there it is likely to appear in the investigation process new evidence that may serve as to argue in the third state, the receiving state, that you didn't only commit one specific criminal offense, but that you commit the most, or you commit even more conducts. However, if those figures or those specific offenses are not even considered in the extradition treaty, then the offender or the alleged criminal offender shall not be subject to investigations of those other conducts. The speciality rule, though, generally not conceived as a rule of comparing individual rights, but rather as a rule derived from the principle of legality, as I previously mentioned, nevertheless protects the alleged offender from having to face charges of which he or she had no notice prior to the transfer, that is, prior to the extradition process. So if I'm not charged with a specific conduct and the receiving state receives me with a whole new list of conducts, then that's in detriment of my rights, right to justice, and even in jeopardize of the extradition agreement. Now we shall move on to the circumstances precluding the return, and that there are certain situations in which extradition is not possible or even shall be precluded. In common law countries, basing their criminal jurisdiction strictly on the territorial principle and being thus unable to prosecute their own nationals, the principle of citizens or the rule of citizens is considered as that is not excluding extradition of citizens altogether, usually concede to the requested state, to the right to deny extradition of nationals if their domestic law so provides. That is, that there has to be a non-discriminatory clause in somehow that provides that extradition will only be on the table when it comes from specific citizens of specific countries. Some extradition treaties restrict the requested state freedom to naturalize alleged offenders after demand has been made for them. Others oblige requested states to institute criminal proceedings for their part if surrender has been refused on grounds of nationality. That is, that I cannot not only create a law framework in which I generate a negative discrimination towards specific citizens of one state, but also if under the process of extradition, the receiving state decides to concede or grant nationality after fulfillment the migratory requirements of the alleged criminal offender, Then after the process of extradition, the surrender state is on the right to deny the entrance of that person because it somehow lists the citizenship. And even so in the other case, I cannot say that I wouldn't give extradition to specific persons if I decided to naturalize them as citizens of my state. And that's a circumstance that preclude the return. For example, in the area of applicability of the framework of decision of the European arrest warrant, it is considered in some of the countries of the European Union that when a state is going to prosecute their own nationals for offenses committed abroad, those broad countries, the third country in which the offense is committed, are not, or in somehow are not authorized under the figure of extradition to deter the extradition by saying that they are going to naturalize the offender. But however, if naturalized, that will preclude the return to the requesting state. There is another rule that governs the circumstance precluding the return, which is, of course, the capital punishment. Under most extradition treaties and statutes surrendered, a surrendered person may be denied, and a surrender request may be denied if in the receiving state, the sanction that is going to be imposed is precisely the capital punishment or the sentence of that. Of course, other types of circumstance precluding the return are also the procedural defects. In recent statutory, how to say, law and agreements regarding the precluded figure of extradition, if there is a reason to believe that the criminal proceedings in the requesting state have not been or will not be in conformity with the rules of human rights or even with international law or the international minimum standards of procedure, then I am able to deny, or I am able to deny the request, or I am able to reject by firsthand the request solicitation of the extradition. Another figure that is almost never explored in some cases, but I have one interesting example in terms of Colombia, is the so-called personal circumstances of the alleged criminal offender. There are some cases in which health circumstances, mobility circumstances, or natural circumstances of the person that is going to be subject of the process of extradition may deter the process of extradition as to deny the request or the solicitation proceeding. One of the most interesting cases is in terms of and after the peace agreement in Colombia, one of the most significant leaders of the FARC movement, the Revolutionary Armed Force, and non-state actor here in Colombia that engaged in non-international armed conflict of almost 30 years, which held a specific health circumstances that will in somehow be increased, or its health situation will be in somehow deter or affected if a process of extradition or the health conditions of the receiving country, in this case, the United States of America, were of non-significant character as to preserve the health of the individual. In that case, the alleged circumstances of one of those leaders of the FARC-EP, now today FARC-EP movement, was of major importance when analyzing the figure of extradition. However, this person engaged in afterwards criminal acts that somehow led to the necessary application of the figure of extradition. In the first request of extradition, one of the major arguments of the defense for not to extradite this person was precisely the health conditions of the alleged criminal offender and how those health conditions will not be improved if the person was subject to extradition. Other of the circumstances precluding the return, of course, is the military offenses. While in early extradition treaties expressly provide for the surrender of deserters, as I told you, the figure of extradition comes naturally from the figure of returning deserters to their nationality. As to modern deference arguments and treaties of military alliances, later extradition treaties of national status in terms of extradition usually exclude military offenses from extradition. That is, that if the conduct is related to the military activities that one person engaged on in the country, a state is allowed to reject or even not continue with the process of extradition because it was directly linked to the domestic jurisdiction of one state. Other types of circumstances precluding circumstances precluding the return of a person are, of course, the fiscal offenses, which are related to tax evasion, violation of currency or custom regulations, are also on today's modern treaties of extradition excluded from the figure of extradition. Under some treaties, although there are some exceptions where subjects to subsequent additional agreements between the contracting parties dealing with the specific categories of fiscal offenses are considered to be subject to extradition. This is especially directed to great evaders of tax or even fiscal frauds from one country to another, transnational fiscal frauds from one country to another. A more modern view of how fiscal offenses may be subject or not to extradition is provided by taking into account the danger to the national economy and the extensiveness of the damage caused by the offender, especially if you analyze that damage affect the public budget of your national terrestrial or your national country precipice. Recent extradition treaties and statutes therefore no longer exclude fiscal offenses, but those fiscal offenses that are subject to extradition are considered as to be great criminal offenses in terms of the impact that they have in their national country, or even in the cases of transnational organized crime. One of the major examples of that is precisely what happened with the Odebrecht case, in which major investigations of international characters and requests of consultation and mutual criminal assistance in Latin America were considered for fiscal fraud and tax evasion and corruption by members of the Bureau of Directors of the subnational entrepreneurships and the subnational partnerships of Odebrecht figures and enterprises. And finally, in terms of circumstances precluding the return, there is the political offenses. The political offense exception is based on humanitarian concern for the offender on the one hand, and to the reluctance of states to become involved into the political process of another state. So when you commit a specific political crimes, those political crimes, if they are the basis for a possible case of extradition, they are not subject to the figure per se because they are entirely related to the relation that that individual has with with the national country or the country of its nationality. Pardon me. So, for example, in terms of rebellion, in terms of heresy, those type of offenses are commonly not subject to extradition because that will imply that a third state is interfering and possibly violating the principle of non-intervention under the United Nations Charter and under customary international law in the political affairs of one state. And remember that political affairs are normally considered as part or subject to the domestic jurisdiction of one state. And the final circumstance precluding the return, in terms of the most known circumstances precluding the return, or even precluding the access of the figure of extradition, is the discrimination clause, which is related as well to the citizens clause. Recently, a so-called discrimination clause has been added to the political offense exception, and that is when underlying a humanitarian background, you have an exception in which in the country of a receiving state, that person that it is considered to be an alleged criminal offender or a criminal offender will be treated under a discriminatory basis. And you may wonder, well, that's the common case of every extradition of Latin American citizens or of more citizens criminal offenders if they are going to be extradited. to the United States of America, for example, they are going to be treated under discriminatory frameworks. So why the countries do not allege the discriminatory clause? The requested party, and you should consider that this discriminatory clause or the discrimination clause is of significant political character, because by arguing this, you are arguing naturally that the receiving state is a discriminatory state. And that's really bad perceived in the international community. If the requested party has substantial grounds for believing that a request for extradition for an ordinary crime has been made for the purpose of prosecuting or punishing a person on account of his race, her nationality, her political opinion, or the sexual orientation in nowadays cases, that person's position may be prejudiced by for any of those reasons, and therefore you have a ground to reject extradition or the request of extradition. This clause focusing not on the political character of a potential offense, but it rather focuses on the political character of an eventual persecution, which is different of prosecution. That is, when you have grounds to believe that the request of extradition is not based on initiating a prosecution process, but rather to initiate persecutions against specific citizens, that is a base to somehow reject the possibility of initiating the process of extradition. Yet, however, that's an exclusion based on obligations beyond the treaties of extradition. Then we will move on to the procedure of extradition and the related procedures. Extradition proceedings are initiated only upon formal request. As I told you, this is a formal procedure. This is really, really formal, and usually communicated through diplomatic channels, diplomatic communications, exchange of letters, consultation processes, except, of course, for the cases of requests under the European arrest warrant, which are competent judicial authorities. Under the arrest warrant of the European Act, the request is considered to be fulfilled if considered to be in conformity with the requirements of the European Arrest Warrant Act, should be granted immediately, unless one of the exceptions that I previously talked with you is put under the table. And of course, the request and the process, it must be supported by those documents that specify the applicable extradition treaty, or in the absence thereof of the treaty, by the extradition arc of the requested state. However, there are some additional or related procedures to the extradition process. Conditional surrender is one of the most interesting figures in terms of related procedures of extradition. An alleged offender surrendering to the requesting state may not, without the consent of the requested state, be surrendered to a third state unless he or she has not left the requesting state after being free to do so, or a fixed period of time. That is, that it cannot be the surrender of the surrender. An alleged offender which is surrendered to the requesting state is not able, without the consent of that requested state, to be surrendered to another state to in somehow pay or to fulfill with the justice, to appear before the criminal justice of another state. So the most basic example of the conditional surrender is that if I am extradited to the United States of America, I may not be subject to an extradition from the United States of America to the European Union if I do not have the consent of the United States of America. So the first surrendering state is not put now under the table, but rather the one that has the power and the faculties of control of me, which is the requesting state, which is now my local state, is the one that shall give the consent as to whether the person shall be surrendered once again to another country. Unless, of course, that person has no left the requesting state after being free to do so. And that is the case, for example, when I fulfill entirely with my condemn or my sentence or my judicial sentence or the judicial decision that condemned me to pay some time in jail or some time in prison. And I am then, after fulfilling that specific period, let's assume I am condemned to 20 years of prison. Then after the 20 years, I decided to continue to live in the state in which I pay my sentence. Then I shall not be subject to surrendering, but those states and the consent of those states um, should not be of significant importance. That is that the consent is not required if that person is no longer among the power of the requesting state. Another figure of related procedures of extradition is precisely what it is called the transit figure, or sorry, the re-extradition to a third state, which is different from the conditional surrender. Re-extradition to a third state is considered a case law or a case framework in which an alleged offender surrendered to the requesting state may not, without the consent of the requested state, be surrendered to a third state unless he or she has not left the requesting state in those cases. The major difference of conditional surrender and re-extradition to a third state is precisely that in conditional surrender, an alleged offender serving a sentence or facing criminal proceedings in the requested state may be surrendered temporarily if the requested state undertakes to return him after the termination of the proceedings. So, what is the difference? In conditional surrender, I may be, as I told you before, I may not be subject to a third state jurisdiction unless there is consent by the third party with the intention that that person is going to be returned to the requested, to the surrender's second state. In the re-extradition to a third state, I may not be able in its entirety to be subject to the extradition to a third state if the requested state has not given the entirely consent to do so, even after, or unless, sorry, I am already fulfilled my time of jail in those case law. There are also some other case laws in terms of related procedures which are transit. In transit, it is considered when an alleged offender from the requested to the requesting state through the territory of a third state depends upon the consent of the latter. What's the case, for example, when in order to initiate the process of extradition from Colombia to, let's assume, the government of China, although it's not a proper case because there is not directly a treaty of extradition, there are some consultations, but just let's assume that I have to make a temporary pass to certain other jurisdictions. So the third state, for example, if I'm going to be extradited to the government of China, but it is impossible to do the process of extradition directly, but rather I shall pass or make a scale in terms of aviation or a stop. For example, in Spain, I must have the consent of the government of Spain to be in transit in the government of Spain for extradition processes. So in these cases, there is a third state which is not going to exercise jurisdiction, but rather is going to be as a state of transit. In order to do so, the transit state shall give its consent to the parties of the extradition process. And finally, there is one of the most complicated issues of extradition, which is the concurring, or which are the concurring requests. A variety of rules provided for in extradition treaties for cases where extradition is requested by more than one state. If requests are made for the same offense, the requested state has to give precedence to the request of the state in which the offense was committed. So there is a special rule. For example, if I commit an alleged offense of cyber delinquency or cyber offenses, in which the territory for commission of the act was the United States of America, but in engaging in that specific conduct, I also affected rights or interests of citizens in the European Union, and both the European Union or countries of the European Union and the government of the United States of America request me for extradition, my country, that is Colombia, shall give prevalence to the United States of America because that was the country in which the conduct was committed in a material form. And that's in somehow the principal rule. But then in nowadays scenario in which from Colombia, I affect directly certain databases or stole data through phishing or major hacking processes to a significant number of countries, that the issue comes more complicated because then I will have concurring requests not only by the government of the United States, but also by the European Union, some African countries, and even so some Asian countries. And it then shall be considered that in which territory there was a more significant damage or the seriousness of the affectation in which country was of a more large scale. Then that should be the prevalent criteria. In order to finish with this lecture, I'm going to talk and give you some examples, general examples of existing treaties of extradition, both Europe, in African countries, and in the Americas. First of all, in terms of bilateral treaties, there is not like a database per se of reliable figures for existing bilateral extradition treaties due to the unknown number of unregistered treaties. There are a significant large number of treaties of bilateral character of extradition. That also includes the processes of consultation, the exchange of letters, or even the extradition process itself. Yet, however, we have some multilateral treaties that may provide some lighting as to how the figure of extradition works. You have, for example, in terms of general in the global scenario or the global standard, we have the Convention of Legal Aid and Legal Relations in Civil and Family Matters, which is the Minsk Convention of 1993, which also provides for some rules of extraditions, for example. In Europe, you have the Convention of Extradition of December 13 of 1957, which I believe entered into force in 1960. I don't know specifically the specific date, but I know that it's from 1960. You have also the additional protocols to the Convention of Extradition in Europe. You have the protocol to the European Convention of 1978 relating to fiscal offenses, judgments in absentia, or amnesty that has been in force since, I believe, 1983. You have the third additional protocol to the European Convention of Extradition that it's aiming to a simpler and accelerated process of extradition in cases of consent by the alleged offender. And that's the case in which the offender considers that it will be better for him to be extradited than be judged in its own country. You have also the Treaty of the European Union on Simplified Extradition Procedure between members of the European Union of 1995. You have the Council of Europe Act that draws up the convention related to extradition between members of the European Union. You have some council decisions in the framework of the Convention of the European Union. And you have, as I told you, Article 2.2 of the framework of decisions of the European Arrest Warrant Act and the European Arrest Warrant Convention. In terms of the government of Africa, you have a significant large agreement, which is the agreement concerning the extradition of fugitive offenders that was presented by the League of Arab States. And it was opened by signature in 1952, and I believe entered into force in 1954. You have the Arab Convention for the Suppression of Terrorism of 1988, that also provides a figure for extradition in cases of terrorism. You have the Convention on Extradition under the framework of the Economic Community of West Africa States, the ECOWAS, or the ECOWAS, which regulates by 1994 the figure of extradition in terms of economical offenses of significant character. Then you have in the Americas, which is probably our most close case, you have the Treaty of Extradition and Protection Against Anarchy of January 28, 1902, the Caracas Agreement of Extradition, the Central American Convention of Extradition of February 7, 1923, which was ratified by most specifically Central American governments, including Costa Rica, El Salvador, Guatemala, Honduras. I believe Honduras withdrew in 1953. You have the Bustamante Code that was ratified by 15 Latin American states. You have the Montevideo Convention and Extradition of December 26, 1993, which was ratified by 12 American countries. And you have some specific multilateral agreements under the framework of the Andinian Parliament in terms of extradition and model rules of extradition by the Parliament. Although I know that I don't have the intention to make any longer this lecture, because I know that it gives you tons of information. The figure of extradition is of significant importance in the international community because it's normally the most common expression of cooperation throughout and among states under the framework of rules governed by both national systems and international systems that are portrayed in treaties. So the figure of extradition comes of a significant importance when it was analyzed directly by the issue presented to the International Court of Justice in the arrest warrant case. And the figure of extradition should be considered not only by in a vacuum, but other figures come to arise in terms of extradition when you are asking yourself questions of types of jurisdiction that you may exercise in criminal offenses, including the most common question on how the figure of extradition is related to universal jurisdiction or the jurisdiction of surrender and the standard of unwillingness and enableness. And of course, unwillingness is that your state doesn't have the intention to prosecute the crime. And unableness is that although you have the intention, you don't have the means or the methods to actually initiate the process of prosecution or even to sanction. Despite that you have or you're able to prosecute that person, your system doesn't have the strength as to sanction the person in accordance with the offense committed. And that's why I believe, especially in the framework of this Jessup and this year Jessup case, the figure of extradition may come of significant importance to you. And that's why the Jessup Latin American Summer School decided for you to know a little bit better, although this is really general, about the figure of extradition. In terms of conclusions that you may have from the figure, you may note that it is nowadays quite uncommon, but at the same time common in terms that you may hear from a lot of processes of extradition and requests of extradition. But extradition, it's in the vast majority of cases of international law, a figure that it is not only governed by judicial framework, but rather political scenarios that are governed by principles of law and principles of international law, including the principle of reciprocity. So you have to bear in mind the context of your own country in terms of how is the relation between the third or the requesting state countries in terms of applying or not extradition. Nowadays, it is more common to see cases in real life in which states prefer not to initiate processes of extradition. Extradition has usually been emulated or considered as a figure that expresses the failure of your own judicial system. But that's not the case, not necessarily. Yet, however, especially in Latin America, the figure of extradition has this myth to be the best manifestation of the failure of the judicial systems. But of course, there are states with better capabilities to judge, to prosecute, and to investigate specific offenses in which that offense may take of a more serious character and may be considered of more significant importance. And in terms of judicial processes time, will be more expedite and more faster to judge it abroad than within your own countries. So that's the relevance of the figure of extradition in general terms. And I hope this session I hope that this session was of enlightenment for you in terms of what the extradition means and general things of extradition. Of course, if you wanted and you want to take a deep investigation on the matters of extradition, I can provide you some access to a specific lectures that address directly the subject, some specific case law. Unfortunately, due to the time, I cannot ask you about 2 or 3 case law that are of major importance in the international community, especially in the European Union, which are the sovereign case and the case of all case. But you will have under this general idea of the figure some instruments in order to pursue or to dig further or deeper into the investigation process that you may engage as Jessup's students. So I hope that this session has been enlightening for you, and I hope that you mm, understand the figure in somehow, because it's a complex figure. And if you have any question on that matter, please let me know, or please remit it to Claudia through the chat for me to try to give some answers.